Dr. Fred Membe, who is the leader of the Socialist Party in Zambia. Very good evening to you, Dr. Membe. Good to speak to you again. So just unpack it for us. And I know you are amongst the detractors, but just from a general, if at all, objective level, what is being touted about Bill 7? What is it meant to do?
I think the biggest challenge with the Bill 7 is not primarily its contents for now. It's the process.
Okay.
The process was outlawed by the Constitutional Court in its judgment a few months ago. And then it required, to be restarted. But if it has to restart, it will mean it can only come to materialize after August next year. This government wants a constitutional amendment before the elections of August next year. So if they don't do it now, they are stuck. Some of the provisions are there to guarantee Mr. Hichilema's continued stay in power. There are fears that if he doesn't make those changes, it will be difficult for him probably to win the elections and to continue governing. So he wants the changes to occur before the elections. So he's trying to make shortcuts, avoiding the processes that are required by the Constitution and which are required by the Constitutional Court order. And this is where the biggest problem is.
So how did the Constitutional Court order arise, and what has been the process which you suggest has been flawed to reach this point?
To effect constitutional amendment in Zambia, you need to engage the public. You don't just go to Parliament and say, I've got the numbers, Parliament, here is a bill, change the Constitution, amend the Constitution, vote. No. You are required by the Constitution to engage the public. Mr. Hichilema's government did not engage the public. And hence the Constitutional Court order that he should engage, government should engage the public. So they tried to hush up that because they don't have time. To engage the public required an act of parliament putting up an inquiry that is legally founded. They made shortcuts to all that to try and abide by that. But then they have realized that what they have done falls short of what the Constitutional Court required. The government has gone back to the Constitutional Court to try and persuade the Constitutional Court to revisit its decision that outlawed Bill 7 and these processes. If they were comfortable with what they have done, they would have not gone back to the Constitutional Court to seek a backdoor appeal, because that's what it amounts to. The Constitutional Court is an apex court, it's a court of final jurisdiction. It has made its decision, and that decision is final. Now they have gone back asking the court to revisit its own decision. That's desperation. It's desperation.
Now you mentioned the fact that there's a need for... Dr. Membe, you mentioned that the national consensus is the proper way of doing it. In what form would that take, and is there an estimation of how long a period that would then render that process as genuine, as legitimate? And I also want to look at the argument that they might make that what happens in Parliament is representative of the will of the people that voted those parliamentarians there. So therefore, it should be seen as part of a broader public participation.
Yes, parliamentarians are voted for by the people, but they are not above the Constitution when it comes to how things should be done. The Constitution sets up how things should be done, and the interpretation of the Constitution is a preserve, not of Parliament, but of the Constitutional Court. Wherever constitutional matters arise, the final say is with the Constitutional Court. And the Constitutional Court has said the process you have taken violates a number of constitutional articles of the Constitution. So you go back and consult. The consultation processes require them to enact an act of parliament, which is used to do the consultations. After that, a bill is drawn up and presented back to the public again before it's tabled as a bill in parliament. That has not been done.
Dr. Member, I'm not sure if the mute button is active, but unfortunately we've stopped hearing you. But while we get you back on, I do want to ask about the separation of powers. This is something that has been touched on in this constitutional challenge. Are you able to explain to us what has been transgressed? Okay, unfortunately we don't seem to have a very great connection to Dr. Fred Member, but we will see if we can just get him back perhaps on audio to continue with the conversation. So it's an issue of public consultation and trust that is at the fore here with regards to what is happening in Zambia. It's about Bill 7, and critics of it saying it could plunge the country into a constitutional crisis, as you're hearing the leader of the Socialist Party, Dr. Fred Member, say, and he is back with us. So, Dr. Member, I was asking about this issue of separation of powers with regards to the process. What can you tell us about what the stickler points are there?
Yes, the Constitution provides for the separation of powers. The duty of Parliament is to legislate. The duty of the judiciary as a separate institution of the state is to adjudicate. Parliament does not have both powers, to adjudicate and to legislate. Once laws are made, the interpretation of those laws is by the judiciary. And in this case, where constitutional matters are involved, is the court, the Constitutional Court. And the Constitutional Court has made its decision. Parliament is required to respect the decisions of the court. It's not above the court. Yes, they have the monopoly to make laws, but they don't have the monopoly over the power to adjudicate. The monopoly over the power to adjudicate lies with the judiciary. And in this case, lies with the court, the Constitutional Court.
So the fears of executive overreach, are they justifiable? Are they, in your view, warranted? Because there is some who say the lack of public consultation points to a growing culture of authoritarian rule.
If the executive can be given the mandate, can be allowed to set precedent where they can amend the constitution using the numbers they have in parliament at any time, that will set a very dangerous precedent. And society will be crushed from above. We will set up, a constitutional dictatorship. There will be constitutional tyranny, there will be constitutional illegality. And that's not desirable. Yes, Parliament should legislate, but with the control of the people, there has to be consensus over constitutional matters.